Greetings. In this video, I'm going to be talking about the UK Supreme Court, what it is, what its powers are, what kind of impact it has, some of the famous cases it's been involved with, and the impact that it's had perhaps on our everyday political lives in the United Kingdom. The Supreme Court hasn't actually been around all that long. It was set up by Tony Blair and Gordon Brown's governments back in the kind of the 2000s, and it was to replace this old system which you can see behind me here. There used to be a senior court, and it used to be known as the Law Lords, and it met in the House of Lords, hence why I've got the picture of the House of Lords there. So the judiciary, in effect, met inside the legislature, and they were called law lords. So the members of the judiciary that were actually making these rulings were also part of the House of Lords. And you can see why that is a very dodgy separation of powers. Why, by not actually having the legislature and judiciary separate, you can see why the judiciary might not often make rulings that actually affected the legislature. This was seen as undemocratic and an ineffective way to run the judiciary. So, Tony Blair's government set up what we now know as the Supreme Court. The other role that they significantly wanted to change was that of the Lord Chancellor. Now, the Lord Chancellor is a cabinet position, a bit like Environment Secretary, Home Secretary, so it's a position like that. Except this one role used to be in all three members of the government. So the Lord Chancellor was elected to the Commons. They sat in the cabinet, so that's two branches, but they were also the head of the judiciary. So this one Lord Chancellor was Parliament, Cabinet, Judiciary. So they did all three roles. So how can you have a true separation of powers and a system of checks and balances? Because remember, one of the key principles of a liberal democracy, as in the writings of John Stuart Mill and others, is that you have this idea where one branch of government is always able to overrule another, so no one part gets too powerful. And yet, here we have the Lords, the Law Lords, sitting in the Lords, and you have the Lord Chancellor, who is, in effect, sitting in all three branches of government. So this just won't do. So the Constitutional Reform Act of 2005 was the law that really changed things. And that led to the Supreme Court opening in 2009. So sometimes you might hear me, or in a textbook, it might talk about the Supreme Court starting in 2005. You might hear it starting in 2009. Basically, they made the law to change it in 2005, but to build it and set it all up took another 4 years. What did they do? Well, the Lord Chancellor was no longer the head of the judiciary. They established a brand new independent Supreme Court established with 12 members. These new justices were to be appointed by an independent commission, i.e. taking all of the kind of parliament and executive kind of out of it. And the Supreme judges could only ever be removed by a vote in both houses of parliament if they'd done something illegal or something like that. But effectively, their tenure is guaranteed. They can stay there as long as they want to, up until retirement. And so the idea was to create something that was far more independent, far more democratic, a more effective check and balance on the government, and to that extent, they've been relatively successful. Certainly, the Supreme Court now makes far more rulings against the government than the Law Lords ever did. Let's just have a little look at how courts in the UK work and the hierarchy of them. There are lots of courts in the UK. Criminal courts, civil courts, they all handle different types of cases. But the courts have a hierarchy, meaning that if you go to get a case in a lower court, so say you were charged with a crime, you get taken to court, you'll probably be found innocent or guilty, and then if you want to, you can appeal that decision. You've got to have a good reason for it. You can't just say, oh, I want another trial. But if there's a good reason for the appeal, that appeal would then go to the next court, which is higher up, which is normally the High Court. And actually, there's a High Court in Scotland and there's a High Court of England and Wales. So there's a few different High Courts around the place, but there is only one Supreme Court. And every time you appeal a court of a previous decision, it goes up to the next court above it. And most of the time, the Supreme Court and the High Court choose which cases they take. So they might look at a particular case and say, there's no reason to appeal this, there's no controversy, there's nothing debatable here, we're not even going to touch it. But at other times, the Supreme Court will take a case that has been appealed and they'll look at it and say, yes, there is grounds for us to make a ruling, and then they'll hear the evidence and they'll go away and they'll make a ruling, they'll make a decision, and they might make the same decision as the lower court, or they might overturn the decision of the lower court. So what exactly do they do, and when do they do it, and when do they get involved? Well, they spend a lot of their time interpreting law and common law. So there might be a law that's written in statute, which has been passed by Parliament, and then someone might ask, well, does this law actually apply in this situation? And the Supreme Court would have to make a ruling about whether it does or whether it doesn't. And we're going to be looking at some cases like this later in the video, but also in class. Your teacher should have given you lots of lists of cases that you can look at where you can see there's some examples. Now remember, of course, the Supreme Court is only an appellate court. That means an appellate has the word kind of appeal in it, if you kind of squint and add an A, which means the Supreme Court never looks at a case before other courts do. So the Supreme Court will only look at a case once it has been ruled on by a lower court. So the Supreme Court is quite unique in that regard. You'd never go there first. And even the most recent rulings on Boris Johnson and the big ones on Theresa May, they were all dealt with in the high courts before they went to the Supreme Court. They also do something called judicial review. Now, this is where someone challenges the action of a government minister or a government official and says, well, that they've either broken the law in what they've done, or maybe they've gone beyond their powers. Now, the word ultra vires is when someone acts beyond their powers. So if your teacher gives you a detention, sorry, but they're probably allowed. But if a teacher starts taking away your house or something like that, they are ultra vires. They are acting beyond the powers that they actually have. And sometimes people have challenged the government and said, well, you are not allowed to do that. You don't have the power to do that. And then the judges, the Supreme Court, will make a ruling about whether that government minister or that government official has acted within their powers or whether they have committed ultra vires and go beyond it. They also sometimes head up public inquiries. That means that they are actually asked to look at a particular issue, to go away and research it, and to write a report. There are other things it does as well, and some of the textbooks go, sorry about the noise there, I accidentally punched my microphone. Some of the other textbooks go into a bit more detail about the other roles they can have, but these are the two main ones: interpreting law and common law, and acting judicial review, and looking at ultra vires. Here's an example of interpreting law and common law. You may have talked about this case in class. This was a case all centering around a gentleman whose surname is Dougie, hence why the case is now known as R versus Dougie. Now, these gentlemen went out together, got drunk, had drugs, and eventually ended up killing one of the men they knew, which is obviously incredibly sad. But one of the men did it while the other man shouted encouragement to do so. And this was Dougie. Dougie was not the man that killed, not the murderer, but he encouraged the other man to do it. The question was whether he was responsible for the murder without actually having committed the crime himself. And the lower courts ruled yes. They talked about something known as joint enterprise, i.e. if two people kind of plan a theft together, but then one of them actually does the theft, are they both responsible for the theft, or only the one that does it? And the rule had existed, or the legal precedent had existed, that yes, joint enterprise, you were responsible if you'd shouted encouragement, talked with the other person to do it, planned it together. But the Supreme Court overturned this and said, no, this was a misunderstanding of the law and it was going too far. Because unless Dougie can actually foresee that by shouting encouragement the other man was going to die, then he was not responsible. So think of it like this. If Dougie shouted, yes, go on, kill him, stab him, murder him, then he's legally responsible. But if he shouted, yeah, get him, attack him, hit him again, but not necessarily encouraging murder, then the Supreme Court ruled that actually he was not guilty of murder like the other. So they set a new precedent, effectively rewrote the law, as in because they reinterpreted that law, which meant that Dougie was then charged with manslaughter rather than actual murder. That's one example. There are many others in the textbook that are worth looking at and discussing, and we'll be looking at some more when we look at the EU a little bit later. Now, going back to what the Supreme Court does, they also make rulings about whether officials or government ministers have overstepped their powers, done things that they weren't supposed to be able to do. Now, one of the famous ones from a couple of years ago is what I've become known as the Gina Miller case. The lady here in the picture, which is probably above my head, sorry, is called Gina Miller. And when Theresa May was trying to take Britain out of the European Union, Theresa May wanted to trigger Article 50 to take us out. So there was a referendum, shall we go or shall we stay? The people voted to leave, and so Theresa May wanted to trigger Article 50. Now, Article 50 is the bit of the document where we joined the EU that said this is how you leave. So she wanted to send a letter to the EU saying this is our official notification, according to Article 50, that we wish to leave the EU. But she was challenged by Gina Miller that she was overstepping her royal prerogative powers. She argued that actually only Parliament had the power to take us out the EU. Now, of course, there were lots of arguments flying around. Some people said, well, we've held a referendum, so why do we need to go through Parliament again? Some people said, well, Parliament approved the referendum, so surely that means they're behind it. But nevertheless, the challenge was successful. Both the High Court and the Supreme Court both ruled in favour of Gina Miller, and effectively this meant that the power to leave the EU was taken away from Theresa May and given back to Parliament, or reinforced in Parliament. So the judiciary ruled that the executive cannot ignore the legislature in regards to foreign affair treaties in this way. So Theresa May then had to send it through Parliament, and to be honest, it actually went through very, very easily. But it did start the process of Parliament having to be far more involved in the negotiations to leaving the EU. And we'll know how this story ends because Theresa May failed to get her deal through Parliament on multiple occasions. And you can actually draw a lot of this back to the Gina Miller case, where Theresa May was first forced to start re-involving Parliament in her negotiations. So the impact of this case was pretty big. And you can read more about it on page 278 of the textbook we've been looking at in class. And I'd certainly encourage you to do so, or maybe to Google a short video, because it's definitely worth making sure this case is very, very clear in your mind. Another one would be the case from right at the end of last year, where Boris Johnson tried to prorogue Parliament, saying, right, Parliament isn't sitting for the next few weeks because we're going to have a Queen's speech. But he also did it at a time when Parliament was supposed to be debating his withdrawal agreement, and that was challenged again actually by Gina Miller, and it went to the Supreme Court, and the Supreme Court ruled that Boris Johnson did not have the power. He had overstepped his power, ultra vires again. He'd gone too far, he didn't have that power, and Parliament should be reopened immediately, and they were. So two very good examples of the Supreme Court, firstly doing judicial review and ultra vires, and thirdly actually overruling the executive and preventing them from doing something. Judges also get involved in public inquiries. Now, to be clear, this isn't the Supreme Court, this is the judiciary. And they can be asked to do lots of different things, normally set up by the government in some way. And some people think actually a government sets it up because they don't want to deal with the problem, because these inquiries often take a number of years to report back. And so by setting up an inquiry, a prime minister is basically kind of saying, well, someone else can kind of deal with this in a few years. But perhaps I'm being too cynical here, because they also look at an issue in great detail, taking evidence from lots of witnesses, and make recommendations that sometimes are put into law. But also sometimes judges make recommendations and then they're ignored. Here's three examples. In the Leveson inquiry, the judges were asked to look at the invasion of the media into personal privacy. This happened because there had been a number of cases involving celebrities and members of the public where newspapers had invaded their privacy massively in order to get a good story. The judge eventually ruled that there should be new laws in place to restrict what the media could do. However, the government was very uneasy about it because they felt this might be removing the freedom of the press and maybe even lead to a kind of a form of censorship, and actually did very little afterwards. Partly because the media kind of set up their own self-regulation committee, and I think basically what's happened is that the media are trying to regulate themselves, and depending on what happens with that, the government may revisit these ideas, but probably not. Now, the Hutton inquiry and the Chilcot inquiry were both set up to look at issues surrounding Iraq. The gentleman in the middle is Dr. David Kelly, and if you go and watch the Andrew Marr History of Modern Britain Tony Blair episode, you can find out a lot more about his story. And the Chilcot inquiry was looking at whether Britain should have gone to war in Iraq. And basically they ruled no, we probably shouldn't have done. But again, nothing really happened as a result of it. But certainly a lot of people did feel that they were able to get their day in court. Now, there's loads of other cases that you could look at. There's some really good pages in the textbooks that go through a whole bunch of cases. And whilst the specification doesn't say you must know this case or that case, I think it's really worth you spending just a bit of time learning a bunch of cases, because there are different examples that you can use in different places, but also just increase your understanding about what it is actually that the Supreme Court does and what they spend their time doing and the kind of rules that they make. So does the Supreme Court actually have any influence? It's been set up, they make rulings in this case, but what are the arguments that say yes, they have a huge impact? What are the arguments that say no, they have very little impact? Well, on one side, they can prevent executive action. They prevented Gordon Brown from holding terror suspects under house arrest for long periods of time. They prevented Johnson from proroguing Parliament, prevented May from leaving the EU without parliamentary approval. They are the final court of appeal for the whole of UK. So the Supreme Court is above the Scottish courts and above the English courts. The Human Rights Act, which of 1998 has increased the court's ability to make rulings, because there is now a piece of legislation that lays out all of the human rights of the citizens in the UK, which means citizens are have found it far easier to make appeals to the Supreme Court using this act, saying they've done this breaks my human rights, as you can see in the Human Rights Act, and the Supreme Court has made lots of rulings based on that act. The Supreme Court has been significantly more active than the old law lords in the House of Lords, and if you just look back at the history of when the government has been overruled, it very, very rarely, if ever, happened back with the law lords, and the Supreme Court is increasingly becoming more powerful from that respect, to the point that actually sometimes they have been attacked by the media and even attacked by the government for the rulings that they have made. Which leads me to this point. The Supreme Court has now ruled against the government on numerous occasions, and if you were in my lesson last week, I was looking at a politician that's come out and said, well, the Supreme Court has become too powerful and have started making rules of their own. The newspapers once described, or the Daily Mail once described the Supreme Court as enemies of the people, saying they were challenging democracy and all sorts of aspects like that. So in a way, they're kind of becoming more political in that their decisions are having a bigger effect. But there are also arguments to say, well, they're not very influential. I mean, firstly, not many people know the members of them. I mean, compare this to America, where almost like the Supreme Court judges are mini celebrities. Over here, they're almost unknown as kind of public figures. But more importantly than that, they cannot strike down statute law. They cannot just say, well, that law's wrong, get rid of it. Because they always have to look at the legal system, what laws are there. And the only thing they can actually do is create a declaration of incompatibility. So they could say this law is incompatible with this law, and they can make that an official declaration. But that comes down to, then the government actually then has to go away and kind of deal with that if they wish. The Supreme Court doesn't have the power to say, well, that law no longer exists, unlike in America where they can. And part of the reason for that is because in America you have a constitution, and you have higher laws and lower laws. And if a lower law conflicts with a constitutional law, then the Supreme Court has the power to say, well, boom, that law has gone. The UK court does not have that power. Also, Parliament can always overrule the Supreme Court. If the Supreme Court makes a judgment that overrules the executive or overrules Parliament, all Parliament has to do is make a new piece of legislation that undoes that law or changes that law, and the Supreme Court has to fall in line. Because the UK Supreme Court does not make any decisions off its own back. Theoretically, it only makes decisions that reflects the law as it currently is. So by changing the law, the Supreme Court then has to follow the new instruction. And because we have no higher and lower laws, a new law can be made by simply 50% of the House of Commons plus one is enough to effectively overrule the Supreme Court. And linking that point together, the Supreme Court cannot rule beyond the law. The Supreme Court can never kind of say, well, we think it's time that this law was in place, or we want to change human rights, and in the case of euthanasia, even if they personally might agree with euthanasia or think it's time that the law was changed, they cannot do that. They cannot make rulings beyond what the law actually is. They have to wait for the government to make legislation for it. Again, different to America, where the Supreme Court has actually been one of the biggest initiators of new rulings that give citizens rights. And lastly, They're not elected. They are appointed. They may well be more independent than the American Supreme Court, but they are unelected, and therefore they will always be less influential than our politicians and our legislature and our executive. Thanks for watching. Hope you found that useful. In the next video, we'll be talking about the relationship between the various branches. There's loads more to learn about the Supreme Court, so do go away, do some reading, look at the revision guides, look at the textbooks, find out more about them, and get your own opinions on whether you think they've been effective. Thanks for watching. Bye-bye.